What's going on with the Ninth Circuit, and why exactly are they throttling Trump's immigration policies? Yesterday, a ruling came down from the Ninth Circuit that essentially stopped what President Trump was trying to do in forcing immigrants who come here to be able to pay for their own health insurance. I did a Periscope on this in detail, and that's what's coming up. But first, before we get to that, please, if you have not already, hit subscribe, youtube.com/humanevents. It'll help us out a ton. Okay, so today, some news that went a little under the radar. You might not have seen it, but it's actually fairly important. Something highlighted in this National Review article by Ed Whelan. The Ninth Circuit issued a ruling on a Trump order that barred immigrants from getting into the country if they couldn't afford health insurance. So the Ninth Circuit has basically, that order was like essentially attempted to be put in place back in October. Political article here. This is a little inaccurate. Trump needs to suspend visas for uninsured immigrants. It's not quite right. Rather, it's saying that in order to get a visa, you need to be able to demonstrate the capability to purchase health insurance. That's this order right here. Again, quote, suspension of entry of immigrants who will financially burden the United States healthcare system in order to protect the availability of healthcare benefits for Americans. I mean, this isn't really that complicated, right? Like we talked about how, there's a pretty obvious popularity, the idea that illegal immigrants shouldn't be able to get free health care. Well, similarly, like there's a corollary to this when it comes to legal immigration. The idea here was to say that in order to both protect the availability of healthcare benefits for Americans and to protect the national interest, we're not going to issue visas to people who can't demonstrate the ability to pay for their own healthcare without government subsidy. It seems like a very basic idea, right? Government subsidy comes from taxes. If you're coming into the country, you should be a net contributor, not a net recipient of government benefits. So not like that complicated, but welcome to 2020, welcome to the world. That's not what happened here. Guess what? The courts weren't having it, especially in the Ninth Circuit. Back in late November, a federal judge issued an injunction blocking President Trump from doing this, from restricting visas for immigrants who can't demonstrate an ability to pay for their own health care. This was Judge Michael Simon in Oregon. So just some random district judge in Oregon, maybe in Portland, maybe in Eugene, was able to issue a nationwide preliminary injunction preventing Trump from putting in place this order. It's kind of weird. Again, think about that, the amount of power that was concentrated in this judge, where that power came from. And this injunction was essentially the government applied for what's called a stay. We'll talk a little more about that over the course of this. They applied for an emergency stay. That was rejected back in December. And then they applied the formal opinion on this, just for the stay of this injunction, was issued today on May 4th. So, this policy enacted back in October has been out of commission since November. And it's very bizarre because, again, this would seem to be something that the president has the authority to do. So let's kind of look through the opinion. This is the relevant opinion. So this is Ninth Circuit opinion. This came out today, May 4th. And we have, it's a 2-1 decision. The 2-1 is with Thomas and Berzon on top, and then Bress dissenting. So understand, like, technically what's happening here, okay? The panel denied the government's motion for a stay pending appeal of the district court's preliminary injunction enjoining this presidential proclamation suspending the entry of immigrants. Okay, so again, so to understand what's happening here, right? The lower court, the district court, heard this case, somebody sued, and the lower court issued a nationwide injunction. And so now this case is on appeal, but it's the earliest phase of the appeal. So the question is whether or not the appeals court is going to leave that injunction in place, or what's called a stay the injunction and allow Trump's executive order to take effect, Trump's proclamation to take effect. And so the answer here is that they said, no, you can't. We're going to leave this in place. Sorry, government, you're just going to have to deal with the fact that you can't enforce your own order. Now, here's the thing about this opinion. This is probably why you haven't seen that much reporting on it either. It's a 97-page opinion, and the opinion itself is in 97 pages. There's like a 30-page majority opinion and almost a 60-page dissent from Judge Bress. Judge Bress is a very new judge on the Ninth Circuit, just confirmed recently. He was nominated in January 2019, and he finally was confirmed on July 9th of last year. So he's only been in sitting less than a year. Very young, 41. So very important judge, like a good thing that we're actually getting this guy on the court. But let's talk about like the substance of this opinion. So there are basically two big arguments when it comes to a stay and an injunction. The first is who is likely to succeed on the merits, right? This isn't going through a full trial yet. We're not even close to that. Injunctions are issued at the beginning of litigation, and they're designed to like hold the status quo in place, or prevent irreparable harm to someone. So again, first question is like, how likely are you to succeed on the merits? That's sort of, a somewhat abrupt evaluation of that, but it's still evaluated. And then the question is, is the person applying for it suffering irreparable harm? And there's a couple other factors: interest of the public, harm to the other litigants. But those are the two ones that are really focused on in this opinion. And it's the two places where these two Democrat judges are completely, in my judgment, off the reservation. I mean, reading through this opinion, it strikes me as unbelievably lawless. Like, just remarkably lawless what the district court judge in Oregon did and what these appeals judges are doing. So let's kind of talk about why. So again, basically the first part of this opinion, this is getting through the syllabus. It takes a while. But the first part of this opinion has to do with Ken. Let's see if we can find that first. So basically, again, it's talking about request for a stay pending appeal is based on these Ken factors, and they're right here. Namely, 1, whether the government has made a strong showing of likelihood of success in the merits. 2, irreparable injury. 3, whether the state will injure other parties. And 4, where the public interest lies. And you'll notice that the first factor is supposed to be the strong likelihood of success in the merits, but it's inverted. The majority starts with irreparable harm, and they make an argument that basically the government has not shown irreparable harm, that the government itself is not irreparably harmed, their argument, by the fact that they couldn't put in place this order about like that they couldn't enforce this proclamation saying that immigrants who come here need to be able to pay for their own health insurance. Now, that's really, really sketchy, right? That's a very sketchy argument, and the reason is highlighted very well in the dissent. So just kind of zoom to the dissent, if you will. This is not the majority opinion, but this is the dissent from Judge Bress. And he says, quote, "The harm that the court's injunction inflicts is irreparable and real to the interest the executive seeks to promote through the proclamation and the core separation of powers principles that make the proclamation lawful. The injunction is a severe affront to the president's authority, itself an irreparable injury." So, Bress's first point on this is like, wait a second. You're telling that the executive branch of the United States federal government that it can't implement its own proclamation about immigration based on the law. That itself is an injury. And he cites what's not actually an opinion of the court, but an opinion from Chief Roberts himself in Chambers. And I have that opinion right here. So this was the reason it's only Chief Justice Roberts is that when it comes to stays and the opinions that the Supreme Court issues about whether to stay a case or not, they're actually issued by individual judges often. And so this one was issued by Judge Roberts himself. And one of the things he said when he was issuing this injunction is, quote, "Finally, the decision below subjects Maryland to ongoing irreparable harm because any time a state is enjoined from a court by effectuating statutes enacted by representatives, it suffers a form of irreparable injury." And that sort of makes sense. There's an institutional injury when a state can't implement its own laws that its representatives have passed, right? And if you say there's a 6-month period where you don't get to implement your own laws, that's 6 months you don't get back of that. And even if there's not like tangible monetary damage, the argument here is that itself is an irreparable injury, and that has some sway on the court. But that's not the only argument that Judge Bress points out. It's not just about the institutional injury. He says that there actually is irreparable harm that will result from the government not being able to enforce this order. The irreparable harm that will result, rather, is if people who can't afford healthcare are in the country and they get their visas, those visas aren't getting rescinded later on. They just get their visas and they get to come. And so they're here and they're hurting our healthcare system. And, it's like he talks about how the scope of the injunction confirms this, that it's, this case actually has a class of a huge number of current applicants as well as potential applicants all around the world. And also, the harms are not purely monetary. Oftentimes when, you're implementing an injunction, if it's purely a monetary harm, you can't get one, because the idea is, say whatever your action or whatever you want the court to do, the only thing they are protecting is like you from monetary damages. Well, then you won't be able to get an injunction, because the idea is, well, if you've suffered monetary damages, they can just pay you, right? Like that's the opposite of irreparable injury. But one of the things that Bress points out, it's not just irreparable. Like, you can't change the harm that's done with strains on emergency rooms and overcrowding. And I mean, especially in the area of coronavirus, like, we're thinking about overcrowding all the time. The idea that this wouldn't be like a serious injury that could occur, I mean, that's a little bit unrealistic. So I think it's pretty clear that on the side of irreparable injury that, Bress has it right in dissent. But the other point Bress makes is that it's not just that there's this irreparable injury, it's that they've completely inverted the order in which you're supposed to confront these things. And the issue is, like, I'm trying to scroll up to that point. It's a long opinion, you understand? Like, I remember like going through like a 20-page opinion. And the issue here is that they have completely butchered the interpretation of the relevant statute at issue. So again, the statute that's relevant here is 1182F, and this should be familiar to if you're a legal hound, because 1182F is the statute that talks about the president's authority to simply suspend immigration from any class of immigrants when he deems it in the national interest. This is the stuff that was behind Trump's travel ban. This is the stuff that's been behind a number of different executive orders and proclamations that the president has issued. So it's 8 U.S.C. 1182, inadmissible aliens, which talks about who might not be admissible. And then it's subsection F, whenever the president finds that an entry of aliens or of any class of aliens would be detrimental to the interest of the United States, he may, by proclamation, suspend the entry of those immigrants. Now, that's a really broad and deferential power. And yet somehow, in this opinion, the majority is saying, like, actually, no, that doesn't allow him to suspend the entry of immigrants who are here or who would like a visa and can't prove that they can afford healthcare. Like, it takes a lot of tortured reasoning, but we'll get into it in a second. So again, if you'll give me a little patience here, so I can scroll through it, that when they finally actually they get past the irreparable harm. Basically the government's argument that this doesn't work, that the proclamation is unlawful. It starts with, the proclamation conflicts with the Violence Against Women Act, which says that certain immigrants are accepted from this public charge exclusion, and therefore that they're fine. I'm pretty sure Bress has an argument that this is totally irrelevant. Like, basically what the majority opinion tries to say is, look, there are these other rules that determine when an alien is inadmissible, and those rules are conflicting with the rule that gives the president discretion to do what he wants. And so if there's any tension between the president's proclamation and these other rules, then the proclamation is illegal. But the fundamental point is, again, like, 1182 is on top of every one. I mean, this is an entire like statute full of reasons why you couldn't be admitted, and 1182 is on top of all of that. 1182 is saying, in addition to all these other reasons why an alien might be inadmissible, if the government makes a determination that it's not in the national interest for a class of immigrants to be admitted, that class can't come in. So, very, very straightforward. And moreover, the other argument that's being made here is this argument about, well, it's not really a suspension, is it? It's not a suspension because you haven't put an end date on it. And the really galling thing here is that somehow the court is like trying to distinguish this case from a Supreme Court case that was ruled on 2 years ago, that case being Trump v. Hawaii, where the Supreme Court explicitly considered the travel ban. This was 2018 case. This is Neil Katyal, my old professor, argued it, lost. And here's the core of that reasoning. So skipping well ahead. The text of 1182F recites it, and this is Justice Roberts for the court. By its terms, it exudes deference to the president in every clause. It entrusts the president the decisions whether and when to suspend entry, whose entry to suspend, for how long, and on what conditions. It is therefore unsurprising that we have previously observed that 1182F vests the president with ample power to impose entry restrictions in addition to those elsewhere enumerated in the INA. Right? The proclamation in that case fell within that delegation. So there's other points in this opinion that really completely foreclose what the Ninth Circuit just did today. Plaintiffs in that case in 2018 said that the proclamation didn't provide a persuasive rationale for why nationality renders the covered foreign nationals as security risks. And as Roberts explains, such arguments are grounded on the premise that 1182 requires the president to do more than just make a finding, but to explain that finding with sufficient detail to enable judicial review. And again, the problem is, there's so much deference here, right? It's whenever the president finds it, he may by proclamation and for such period as he shall deem necessary. It's just, it gives him the decision. This is not something where there's like court oversight, and the Ninth Circuit is pretending that it is. The Ninth Circuit actually attempts to make this weird distinction. Let's see if I can find the actual language where they do it. Oddly enough, Bress points out that there was this attempt to distinguish based on how detailed the findings, but we just literally read the part where in the Trump versus Hawaii case where they're like, it doesn't matter, right? It doesn't even matter whether or not there are these findings. But there's, let's see, there's this other one. There's the question of whether or not it's even a suspension in the first place because it's not there's no final end date. Well, Trump v. Hawaii answered that too, right? I think, it says it right here. We agree with the plaintiffs that the word suspend often connotes a deferral until later, but that does not mean that the president is required to prescribe in advance a fixed end date for the entry restrictions. So, basically, the Ninth Circuit says, well, it's not clear that you're suspending it because it's not temporary. Well, then there's a Supreme Court opinion 2 years ago that says the president doesn't need to put an end date. The Ninth Circuit says, well, you didn't do a searching inquiry. Trump versus Hawaii 2 years ago says you don't need to do a searching inquiry. It's literally the president's judgment. Every argument that the Ninth Circuit is making here was preempted and answered by Trump v. Hawaii. There's one other distinction that I wanted to find because I thought it was just ridiculous. Let's see if I can find it. Here's this weird, another bizarre distinction. The majority opinion tried to distinguish between foreign and domestic interests. The idea that, well, Trump v. Hawaii dealt with foreign national security interests, right? That was about the travel ban from Iran and those 7 countries in the Middle East due to improper vetting. And because of that, as a result, that's where we defer. But we don't defer to the president when it comes to economic issues. And because this about, the immigrants' ability to board healthcare is economic, that's why we can meddle and put in place a massive nationwide injunction that stops him. And the point that Bress is making in dissent is there's no distinction between foreign and domestic interests in 1182. Remember, 1182 just says, whenever the president finds that the entry of any class of aliens would be detrimental to the interests of the United States, he may suspend the entry of those aliens. It doesn't say detrimental to the foreign policy interests. It doesn't say detrimental to the international interests. It just says detrimental to the interests. That is inclusive of the economic interests of the country and the interests of American citizens. There's nothing in this law, and there's no basis for the Ninth Circuit to be getting up there and being well, it's different because it's economics. Nothing. They're just making up a distinction out of thin air. So there's just all these terrible arguments about why this broad grant of authority that the Supreme Court has already found is super broad and has rejected similar arguments before, the Ninth Circuit's still nah, we don't think you can win this one. And it's just doing a whole bunch of mischief because it's not just that we're dealing with the fact that this is an opinion that, stayed an injunction. Think about how big this injunction is. It's a nationwide injunction, right? Again, one district court judge in Oregon put in place an order that said, you, the executive branch of the United States government, you can't do this thing that you can't do this thing and decide which immigrants get to come in the country. You don't get to do it. I, random single district court judge in Oregon, say that's wrong. And I'm going to stop you from doing it anywhere, right? That's a nationwide injunction. And there have been a huge number of those. To the point that the Supreme Courts and a lot of other people are starting to pay attention, right? You have Justice Thomas in Trump v. Hawaii pointing out that he not only joining the court's opinion, but writing separately to address the problem of these nationwide injunctions. He says, injunctions that prohibit the executive branch from applying a law or policy against anyone have become increasingly common. District courts have begun imposing universal injunctions without considering their authority to grant such sweeping reliefs, and they're taking a toll on the federal court system. Like, because think about it, they only need to win once. If you're trying to stop a federal government policy, you can have 100 lawsuits all over the country and 100 in like dozens of different federal courtrooms. And if you just win one nationwide injunction, you're gold. Policy can't take effect. Like, that's a huge problem, and it's not clear that there's any authority to do that. And Bill Barr, in a speech that he gave, he's given a number of speeches on this, but he gave a speech back in May 2019 about these nationwide injunctions. So he's talking about what they're due. First, the nationwide injunctions have frustrated presidential policy for most of the president's term with no end in sight. And this is about the DACA thing. We are more than halfway through the president's term, and the administration can't even rescind the signature immigration initiative of the last administration, even though that was done through executive order. Remember, DACA was not legislation. DACA was an executive order where President Obama was like, I'm not going to enforce immigration law. And President Trump comes in and he's like, okay, I'm going to enforce immigration law again. And the courts are like, no, you have to abide by the previous, you're not even allowed to. We're not allowing you to go back right to the previous way of authority. We're not allowing you to enforce the law. As he points out, they bring the courts in the political process right in the middle of legislative discussions. They keep everything in limbo, and they lead to unhealthy litigation tactics. They're everybody's suing for these nationwide injunctions, and also leading to some conservatives to try and sue for a nationwide injunction to allow the administration to do what he wants. It's a complete disaster. And think about it in this case, right? Just in January, there was a similar stay issued, or the court stayed in a nationwide injunction on the public charge rule, which is saying that it's similar to this one. It's saying you need to be actually able to provide for yourself and not be on the public dole. And in that opinion, there was a concurring opinion from Justice Gorsuch being like, hey, these nationwide injunctions are really annoying. Right? Where is the problem? Yeah. The real problem here is the increasingly common practice of trial courts ordering relief that transcends the cases before them. These orders share the same basic flaw. They direct how the defendant must act towards persons who are not parties to the case. And this is a problem with these because, think about it. It took, they let it go forward, on the 22nd, but they're dealing with this one too. This is a different nationwide injunction that they have to shut down. And in particular, there's a unique problem with this one. This is from the original opinion. This is from an opinion back in December. Same case, different opinion. But it's talking about why was the district court's injunction so harmful and why was it so lawless? It says, the immediate harm is only magnified by the extraordinary scope of the district court injunction, which short-circuits the procedures for class certification by giving thousands of persons not before the court the relief that the class certification is designed to evaluate. So there's a little explanation that happens here. So it's understanding how class action lawsuits work. Most people get it wrong entirely. They think it's a bunch of people getting together to sue, right? That's the natural common interpretation of what a class action is. That's not actually how it works. In a class action lawsuit, one plaintiff steps forward and says, I am capable of representing an entire class of people who were similarly situated and harmed in a very similar way. And so the judge, can deal with me as the litigant representing all of these unnamed class members. For that to fit in and essentially abide by is the wrong word, but jive with due process, there's a lot of rules that go into protecting those class members who aren't unnamed class members who aren't before the court, right? Is the guy who's saying, I'm going to represent all these people, is his harm the same as all of their harms? Does he have some unique circumstances that make it so he's an appropriate class representative? Is it big enough? Is the class big enough to justify resolving all these people's claims without giving them a chance to show up in court? All these little things. And the point being that at this point, when this court opinion issued a nationwide injunction saying, you, President Trump, and you, Trump administration, you can't enforce your executive order on any immigrant, any potential immigrant. You can't do it on anybody. Those people weren't before the court. There's only a few people before the court at that period of time, right? There's 7 people. John Doe, number 1, Juan Ramon Morales, Jane Doe, Iris Angelina Castro. These are the people before the court, and the court ruled that not only did the Trump administration have to allow these people to get their visas, it had to allow all immigrants to get their visas despite and not to enforce this rule about being able to afford health insurance. And that's really remarkable. And here's the thing, there wasn't even a class certified at this point, right? Notice, on April 8th, that's not long ago, that's less than a month ago, the judge granted class certification in this very case. In this very case. And so, let me quickly find where this was discussed. Let's see if we can find it. He talks about how, this is, I think, is the introduction, but he talks about how the majority is allowing another universal injunction to remain in place, but with new and unfortunate twists. When the district court enjoined Proclamation 9945, it did so without certifying any class. So, again, the litigants at that point, they weren't representing everyone who was similarly situated. They were just representing themselves. And despite that, the court judge is sitting there resolving a case just with these litigants, and the judge is like, not only does the government have to, not deny your visas, it can't deny anybody's visas on these grounds. They don't have that authority. It's not a class action yet. But basically they backfilled the class action. The judge finally certified it in April, as Judge Bress pointed out, the government hasn't even had time to appeal this class action certification yet. Because the time they hasn't even filed the appeal, and yet it's being used. So you have this. It's so bizarre. Normally you'd think you would get a class certified and then you would get an injunction on behalf of the entire class. But the district court reversed the order. He granted a nationwide injunction and then certified a class months later. It's ridiculous. It's a way to short circuit essentially the requirements of a class certification. So there's a whole slew of problems with this case. It is wrong on what constitutes an irreparable harm. It glosses over the fact that the federal government and the executive branch not being able to implement its own orders is institutional injury. It ignores the fact that there are a lot of injuries that occur as a result of the fact that hospitals might be overrun. There's a diminution of available healthcare resources, especially with COVID-19. And then on the merits, it's a complete disaster. I mean, this is, 2 years ago, the case that the Supreme Court ruled on, Trump v. Hawaii, handled almost all of these issues and resolved them completely differently. And it's the job of the Ninth Circuit to follow what the Supreme Court says, and they're not doing it, and they're still implementing these nationwide injunctions. So, what we end up needing, and what we get to, is the fact that we're really going to need, the Supreme Court's, I think, going to end up staying this and reversing this Ninth Circuit ruling. It might even do it what's called, I think in sort of without a formal, it might just grant, vacate, and reverse. Grant the certiorari and just vacate the decision. It's so analogous to Trump v. Hawaii, and the attempts to distinguish it are so specious that I think it's just going to get reversed very quickly. But, I mean, what is the Ninth Circuit doing here? And, the Supreme Court doesn't have time all day to be reversing every nationwide injunction against the administration. And the administration should be able to, enact law and implement policy. I mean, what's happening here is essentially you have the courts encroaching on executive authority. They want the ability, individual district judges want the ability to stop the entire federal government from working. And maybe that shouldn't be how things go. Maybe, as Justices Gorsuch and Thomas recommend, we should have a different system where judges can only issue injunctions that bind the litigants in front of them. They don't get to issue maybe they shouldn't be able to issue these nationwide injunctions anymore. We went 175 years without them. Maybe they shouldn't happen. Anyway, that's what I got. Thank you so much for watching. Hope you enjoyed the content. If you liked it, please do hit the subscribe button, youtube.com/human events. It helps us out a ton. Also check us out at Periscope and on Twitter. There I usually operate under my personal name, @WillChamberlain. I'll talk to you soon.